All right. So welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thanks again for joining us this morning. So the Data Practices Office, we're a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. So most of what we do is respond to questions related to those laws from both members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. So this PowerPoint is posted on our website. So if you aren't able to download a copy in just a moment today, it is on the webinar page where you registered. We also record our webinars. So if you missed part of today's webinar, if you want to go back and watch it or watch a different one, they are posted on the Data Practices Office YouTube page. So you can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. All right, so if you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. So bear with me here just a minute while I share that file. All right, there it is. So you should be able to see a pop-up window and download the file. I know for some people this has not worked in the past, so if you are having issues, please just visit the webinar webpage on our site where you registered. If you scroll down to the bottom of that page, this presentation is also available to download there. All right. Today's webinar is another installment of Data Practices Potpourri, and that's where we highlight some of the questions data requesters and government entities have raised in the past month or so. We'll also leave some time for a Q&A session at the end of the webinar. So if you have questions, you can send them in as you think of them using the Q&A panel on your screen. If you do that, please make sure to select all panelists when you send them in so that we can be sure to see them. And you can begin sending them right now if you have them, or you can wait until the end of the presentation. So let's get started. All right, our first question deals with submitting or receiving requests under the Data Practices Act. So many entities have created a general email account to receive requests, something like data practices request at entity.gov or, something similar. So can a government entity use such a general email address to receive data requests? Okay, so for a bit of background first, let's turn to Minnesota Statute Section 1303. So subdivision 3 states that upon request to a responsible authority or designee, a person shall be permitted to inspect and copy public government data. And subdivision 2 states that the responsible authority shall establish procedures to ensure requests are received and complied with in an appropriate and prompt manner. So read together, requests should be made to the responsible authority or designee, and the responsible authority must have procedures in place for receiving these requests. So taking those provisions into account, since the RA must have procedures in place for receiving and responding to requests, those procedures may use a general email address. However, if your entity does decide to use a general email address to receive requests, there are some things to take into account. So first, you should have procedures in place to make sure that the email address is regularly monitored. So who has access, what happens if a person is on vacation or out, and so on. Next, remember that the identity of the responsible authority and any designees should still be identified in your policies. So don't just list the general email address instead of naming who the RA or designees are. Also recall that subdivision 3 of Minnesota Statutes 1303 states that a person may make a request to the responsible authority or designee. So be sure to have procedures in place in case requesters decide to send requests directly to the responsible authority or designee as listed in the entity's data practices policies. So that even though they didn't send it to the general email, your entity can still fill these requests in an appropriate and prompt manner. All right, and finally, if you use a general email address to respond to data requests, just ensure that you are communicating who the response comes from. So if an individual receives a response but needs to ask like a follow-up question, they know who to contact. Additionally, if it is unclear who responded to a question from an entity, then the requester will not know if the response is from the data practices compliance official, the responsible authority, or someone else. And knowing who responded to a question may change, right? The next steps that the requester needs to take. For example, if the requester has an issue with the response from the entity, my office, we would often suggest contacting the data practices compliance official for clarification. But if that response already came from the DPCO, then it is important to know that so that the requester doesn't, go back and essentially require that the DPCO answer the same question again. So, it's in everyone's best interest to clarify where a response is coming from, just to avoid confusion or any duplication of work. The next question is one we get in different contexts, but it often comes up in law enforcement data, right? So who may access private data on minors? So first, I do want to mention that there is no general private classification for data on minors. There may be a private classification that applies, but it depends on your data. So examples of provisions that classify data on minors or juveniles are listed here. Educational data, which is in Minnesota Statute Section 1332, data on maltreatment investigations or delinquent juveniles. If the minor qualifies as a protected identity under Minnesota Statute Section 1382, Subdivision 7. And finally, there may be other sections, right, that classify data on minors. It just depends on the context of your data. So overall, just remember that for data on minors or juveniles, you are still starting with that public presumption, but there may be a classification that applies depending on the data. So feel free to reach out to us if you're unsure of what statutes may apply in your circumstances. But if you do have private data on minors classified maybe by one of the statutes I listed on the slide or something else, then access is determined by Minnesota Statute Section 1302, Subdivision 8, and Minnesota Rules 1205.0500 and 1205.0400, all cited here. So taken together, these state that those listed here on the slide may access private data on the minor. First, and not surprisingly, the data subject may access their private data. Next, we have the parents or legal guardian may access the data, which I'll talk a little bit more about in the next slide. Individuals in the government entity whose work assignments reasonably require access to the private data at that entity may access that data. Then entities authorized by statute, and this can be a big one, right? Since many of the statutes I cited earlier on the previous slide, it classifies the data as private and it also provides for access to a number of entities. So definitely check those out. And finally, entities or individuals who the data subject provides consent for may also access the private data on the minor. All right, so we get questions, right, about what rights parents have to their minor child's data. So under Minnesota Rules 1205.0500, subpart 2B listed there, parents are presumed to have the right to access their child's data. But there are some exceptions to this access. So first, if the parental rights were terminated or if there is a court order limiting the parent's rights, that would apply to data access, then the parent may not access the data. However, under this rule here, the entity would still presume access, and this order must be provided to the entity to withhold access. So there is not an obligation under this rule for entities to proactively investigate whether there are any court orders limiting access. Also, minors may request that the responsible authority deny the parent access to the minor's data. So once that request is received, then the RA must determine whether it is in the best interest of the minor to withhold that data. And the rule cited here, which is 1205.0500 subpart 3, that lays out the considerations for the responsible authority when determining whether to honor a request to withhold data from a parent. This exception to access right here, though, to a request, it does not apply to educational data. So, and on educational data, there is a separate rule for access to education records. So under this rule, the responsible authority may not deny a parent access to education records unless the minor data subject is enrolled as a full-time student in a post-secondary educational institution or has turned 18. So if you are dealing with education records, you likely know, right, that you have some special considerations under the Data Practices Act and FERPA, but they are in the rules cited here as well. The next question, speaking of educational records and parents, We have received a number of questions dealing with recent changes to the Data Practices Act educational data provision, which is Minnesota Statute Section 1332, and directory information. So if a school district designates parent addresses as directory information, can a school district still provide these addresses to requesters? So to begin our analysis, we look at the educational data provision in Minnesota Statute Section 1332, which is the state statute governing education data. And the Family Educational Rights and Privacy Act, better known as FERPA, would also apply to these data. And Minnesota Statute Section 1332, classifies educational data on both students and parents as private. So these data are private, but under FERPA, you can classify certain educational data as directory information. And there are directory information on students and directory information on parents. And directory information then becomes public data on individuals. So there are some limitations on what private data may be classified as public directory information. For example, under federal law, Social Security numbers may not be designated as directory information. And in this past legislative session, the legislature passed new restrictions on what may be designated as public directory information. So the new statutory language states that educational institutions may not designate a student's home address, telephone number, email address, or other personal contact information as directory information. Note that this new language does not prohibit parent addresses from being designated as directory information, just student addresses. However, you can probably guess, right, that revealing the parent's address may also reveal the student's address. So given all of this, our guidance is that schools should not provide a parent address in response to a public data request. So first, because it would be private data under Minnesota Statute Section 1332, but even if you did designate a parent address as public directory information on the parent, if you disclose this parent address, it would reveal not public data about a student. So it would either reveal the student's address if the student resides with the parent, right? Or if you choose to only provide addresses when the student does not reside with the parent, then it would disclose that the student does not reside with the parent. And all of that data is on that student, right, is private under Minnesota Statute Section 1332. So as a result, a parent's address should not be provided in response to a public data request. I should note, though, that in this circumstance, parent addresses may not be released because it would reveal private data on a student that can no longer be designated as directory information under this legislative change. But this new legislative language is specific to students. So other data on parents, like emails or phone numbers, may still be designated as directory information. And if you designate other data on parents as directory information, you may have to release those data in response to a public data request. And just as a final note, these new restrictions do not apply to post-secondary education. So if you are from a post-secondary institution, these new restrictions that I discussed on directory information do not apply. Another question that's come up recently is the classification of warrant data. So are warrants public data? So we are talking about warrants maintained by law enforcement. So we'll be looking at Minnesota Statute Section 1382. And under 1382, subdivision 19, it states that data in arrest warrant indices are classified as confidential until the defendant is in custody, served with a warrant, or appears before court. There is, however, language in this provision that gives entities some flexibility to share this data before the defendant is arrested or served if law enforcement determines there is a public purpose for doing so. And the other provision in the law enforcement statute to watch out for is subdivision 2, which states that arrest or search warrants are super public arrest data. And that's what we call data that are public under Minnesota statute section 1382 subdivision 2, even if the investigation is still active. So this public classification under subdivision 2, that kicks in when an individual is cited, arrested, incarcerated, or otherwise deprived of liberty. So essentially, once an individual is in custody, the data and warrants are public, and this includes arrest or search warrants and indices. So if the warrant has any other data, though, like unprotected identities under subdivision 17, that data would still be redacted from the warrant before providing it. We've been receiving inquiries from members of the public asking for information on appealing a government entity's decision to our office. So if the data requester is unhappy with the response from your entity, how should they submit their appeal to the DPO? This is a trick question. The Data Practices Office is not authorized to hear appeals from entity determinations to data requests. So we are happy to provide technical assistance. So if a requester has questions about an entity's response and seeks clarification or perhaps information on classifications, we're happy to do that. But we do not have authority to review other entities' data or force entities to release data or hear appeals regarding data request responses. So if you are providing this information to requesters directing them to our office to appeal a decision, please note the requester may come back to your office upset because this information is not correct. But I do want to talk a little bit more about remedies available and what appeals our office may hear. So if a requester is upset with a government entity's decision or actions around a data request, then they have some options, right? So civil remedies are available under Minnesota Statute Section 1308, and administrative remedies through the Office of Administrative Hearings are available under Minnesota Statute Section 13.085. Willful violation of the Data Practices Act is a misdemeanor and may result in the dismissal of the government employee under Minnesota Statute Section 1309. And finally, I mentioned in the introduction here, but the commissioner does have authority to issue advisory opinions on both data practices and open meeting law issues. These opinions are non-binding, but are given persuasive authority in court, and entities are not liable for damages or attorney fees when acting in conformity with the opinion. However, this advisory opinion process is not an appeal process. The area where the commissioner may hear appeals is under Minnesota Statute Section 1304, Subdivision 4. So under this provision, data subjects have the right to challenge the accuracy and completeness of data about themselves to the government entity maintaining the data. So if the data subject wishes to appeal the responsible authority's decision to this accuracy and completeness challenge, then they can appeal to the Commissioner of Administration. This process is not for appealing decisions to requests for government data, just for appealing entity decisions on the accuracy and completeness of data about the data subject. And if you have questions about this process, the accuracy completeness challenges, please feel free to contact our office and we're happy to discuss them with you. Okay, the next question. Someone asked, is there a sanction for not updating access policies? So I'm not going to come over from the DPO and sanction you for not updating your policies, but if you don't update your policies by August 1st, you are opening yourself up to actions under Minnesota Statute Section 1308 and 1308.5. So it is possible that a data requester could seek remedies for non-compliance with this particular requirement. So we do encourage entities to update by August 1st. And if you haven't, it's better late than never. And please note on the policy when it was last updated, just so it's clear that the policy is current. And from our perspective at the DPO, we definitely look for and use your access policies and the work that we do with requesters. So we do really appreciate knowing, that we're contacting the right person and that the policies are correct. And of course, for you, it's helpful within your own entity, right, to have updated policies for your own work. So everyone there can understand, what the expectations are for data requesters and who to contact within the entity. We do have model policies on our website, along with a worksheet of decision points for entities if you are looking to revise your policies. And of course, as part of this requirement to update policies by August 1st, you are also not surprisingly required to have these policies in the first place, both for members of the public and data subjects. And in addition to these policies, entities must also maintain an inventory of all data classified as private or confidential, and also have a policy on ensuring appropriate access to not public data. So if you have questions about this, please feel free to reach out. And for more information and examples, you can visit our website. And under the resources tab, you can see a page with information on these policies and other required documents. All right, so those are our questions today, and we are happy to take a look at some of yours. So please feel free to use the Q&A panel. And if you do that, remember to send to all panelists so that we could be sure to see them. There are a few reminders on this slide. So the slide deck is available on our website. So if you had trouble downloading it, you can access the PowerPoint on our website on the webinars page, and you can access the recording of this webinar on our YouTube page in the next day or two. In just a moment here, I'm going to put an evaluation in the polling panel. If you could please fill that out, let us know how we did and what other topics you'd like to see in the future. That would be very appreciated. We want to make sure that these webinars are helpful and useful for you. So thank you in advance for all of your feedback. So I will get that poll up in just a moment here. And if you hear a little bit of silence on our end, everything's still working. We're just going through your questions and getting some answers prepared. Thanks so much.
Okay, we can start with a couple of questions that fall within section 13.82, and that's the law enforcement data section. And so the first part, so I've got two questions here. So what constitutes unique property? Does a green vape pen qualify, or would it need to be more descriptive to be withheld? So this is a reference to section 13.82, subdivision 20. In that section, what it says is that data that uniquely describe stolen, lost, or other types of property can be classified as private or non-public data. So it's less that unique property and more that unique description. And so something like a green vape pen doesn't seem to uniquely describe a particular vape pen. There's probably a lot of green vape pens out there, but some other types of information that might uniquely describe that property, if there is a name etched into it, or particular aspects to that property, maybe for example like a vehicle identification number that's related to a stolen vehicle or a recovered vehicle, that might be something that would uniquely describe property. And so that's some of what I think the law is contemplating there. But there isn't any additional guidance on subdivision 20. So it may be some analysis for each law enforcement agency to decide what is uniquely describing property. And then a similar question, well, not similar, but kind of related to 1382 here, is, under 1382 subdivision 7 regarding law enforcement agencies being able to withhold particular data that are offensive to common sensibilities. The question is whether that offensive to common sensibilities kind of exception to disclosing public data, does that solely apply to images, video, and audio, or could that also apply to a written report? So the language in subdivision 7, I think, makes clear that it applies only to images and recordings, which would include photographs, video, and audio recordings. Those are the types of things. So images or recordings is what can be withheld. I don't think that you're able to withhold the data that are in the written report that might be related to that offensive to common sensibilities, such as maybe swear words or different things like that. I think the point of withholding the audio or the visual data is that it may be a little more visceral in nature or a little more extreme for folks to see if it is really offensive. So that would be, the limitation to that audio and video or kind of those photos and recordings. And just as a side note with that, a law enforcement agency still needs to disclose the existence of those images or those recordings. And so you still need to inform a data requester that they exist. It's just simply withholding access to the images or the recordings when they're offensive to common sensibilities.
I have another question here. This one asks, when police departments are charging for body-worn camera footage, can you clarify what it means to be able to charge for the actual cost of an employee to search for and retrieve data? This is the time it takes to look for the footage and time to download the footage since we can't charge for redaction, or is it searching for and downloading, which might only take a few minutes? The question notes that there's inconsistency within police departments across the state, and some charge as little as $5 and some charge hundreds. So this is a great question. Whenever you get a request for data that are anything other than 100 or fewer black and white paper copies, we're always in actual cost for the way that you calculate your copy costs. But copy costs and what you can charge for copies differs between a member of the public request and a data subject request. With data subjects, which are who's most likely making requests for body camera footage, because most body camera footage is private unless it falls within one of those 4 or 5 exceptions for releasing not public body camera footage. If the data subject is making the request, you're always an actual cost, but you cannot charge for search and retrieval when it's a data subject. You can only charge for time to make and transmit the copies and the materials. You can't charge for search and retrieval, and you cannot charge for redaction. If this happened to be a member of the public requester asking for a copy of body camera footage that was made public, search and retrieval is, like you said, the time to locate and find the responsive data to that data request, but you cannot charge for the redaction.
Okay, another question that we have here is if a warrant is sealed, what is the classification or the citation that folks should use? So this is a great question. Typically, if your agency has a sealed warrant, that's likely going to be accompanied by some sort of court order. And as we've discussed in previous webinars, if anytime you receive a court order, the first thing that you should do is probably review that with legal counsel, because there may be some language in there that describes who may access that warrant. Typically, if a warrant is sealed, it becomes opened, once that warrant is executed, but that may be determined in the court order. And so you'd really want to work with your legal counsel to review that court order to determine how long that warrant needs to stay sealed, whether it becomes available to the public, and if you happen to receive a data request for that warrant in the time while it's still sealed. Again, chatting with your legal counsel to determine the best response. Likely it's going to be, something that is a response where you say, some data have been withheld or we cannot provide access to this data because it's subject to a court order or something similar to that, because court orders can supersede the requirements of the Data Practices Act. So anytime you receive a sealed warrant, I'd certainly encourage you to work with legal counsel if you do receive a data request for that sealed warrant, just so you can review that court order and determine the best approach to respond.
We have another question here. It asks, would the 13.04 10 business day requirement for data subjects be paused while the government entity waits for the requester to provide payment or identity verification? So the statute doesn't say. What we're stuck with in 13.04 subdivision 3 is that government entities have to provide access to the data subject immediately if possible or within 10 business days of the date of the request. There's not additional guidance there on what happens if the individual doesn't respond for identity verification or provide payment. I think in all cases, we expect government and the requesters to act reasonably and in good faith. If the government entity has accumulated the responsive data within 10 business days and reached out to the data requester or the data subject and given them a reasonable amount of time to try to verify their identity or remit payment within that 10 business day timeframe, it's outside of the government entity's control if the person doesn't respond at that point or come and pick up the data or come show their driver's license. This might be something that the entity considers as part of their procedures, right? Having data subjects as part of their request provide some sort of verification. But the Data Practices Act is silent here, and it will likely be a process question. And all I can say is that if you've done your part as the government entity and you've accumulated that responsive data and you're waiting for the data subject to respond to you at that point in time, you've done everything that you can to provide the responsive data, and you can't control if you're waiting for the requester to come and provide that verification.
Okay, so another question that we have here is if an entity delivers data for inspection via electronic remote inspection, is the requester entitled to the data in its original form? If there's different considerations here, if the screenshots are delivered in PDF, so the requester is not able to see who the email was sent to, and they have the ability to open attachments included within the email that contains public data, would this be a violation? I think it probably depends on the circumstance. What I would say is that the Data Practices Act under the Data Practices Act, requesters are entitled to access data in its original format. And so there's no obligation to change format. And so if it's electronic data, requesters are entitled to obtain the data in that electronic format. If it's paper data or physical records, physical data, requesters are entitled to access it in that sort of version too. And so it really depends, if requesters aren't able to see certain data as part of inspection, it could potentially be a violation. But, if there's a particular situation that you're thinking of, please reach out to our office. We'd be happy to chat with you, maybe provide some guidance on that front and kind of figure out what's going on in a particular situation here. But typically, I'd say provide data in the format in which it exists. That's the best way to go.
All right,
One
thanks
last-
everyone. Oh, do you want to do one last one?
We'll just cover this last one because it's
Sure,
a
go
question
for it.
about the one we already answered. If a government entity provides electronic data, the question is whether the entity can also charge 25 cents per page if it's less than 100 pages. So for an electronic PDF, that's electronic data. So we're outside of those paper copies. So it's going to be actual costs when you provide electronic copies of PDFs or other electronic documents. Thanks. Sorry about that, Ellen.
Oh, no, that's fine. Thanks, everyone. I know it is 10:30, so we will wrap things up. If we did not get to your question, we will follow up to provide some information. So apologies for not getting to all the questions today, but we will follow up. Otherwise, thank you so much for attending today. Hope you have a good day and take care.